What if the insurance company for the opposing side wants you to attend an IME?
When you are involved in a lawsuit, meaning your lawyers filed the case against the person who injured you, the sequence usually goes like this. First thing that the lawyers for the other side do is they send you interrogatories. Interrogatories are written questions which you have to answer, and they're in great detail, and you have to answer them under oath. Following that, they're going to send you releases for you to release your medical records, and they're going to gather all the medical records they can, even sometimes going back years before your accident. Once they've gathered those medical records, without you even knowing it, they're going to send those medical records to a nurse or to a doctor to review and to write a lengthy medchron, or a lengthy medical chronology. That's something that's going on behind the scenes that you don't even know about. Following that, they typically will want to ask you questions under oath. Lawyers call that a deposition, and they're going to be asking you about your medical history and everything else. Sometimes cases will settle after they've taken your deposition. But if they don't, and the case looks like it's likely to go to trial, then the insurance company for the party that's defending the person that you've sued, they're going to want you to go to a CR35 examination. Plaintiff attorneys call that CR35 examination, which is named after the Civil Rule 35 exam. We also call those defense medical examinations, or even insurance medical examinations. Defense attorneys and insurance companies, they call them something different. They call them independent medical examinations. They like to claim that the doctor that they've hired to examine you is independent and not biased or swayed like your own medical providers might be. What we've found over the years is that those doctors are anything but independent. They, over and over and over again, they give opinions which are favorable to the party that hires them. And the party that hires them, of course, is these insurance companies. So oftentimes they will say that you were not injured, or if you were injured, that you weren't injured anywhere nearly as badly as you claimed that you were, or that if you were injured badly, that your injury is resolved within a few weeks after the accident. Sometimes they'll say that your treatment was excessive, you shouldn't have gone to all those chiropractic visits, all those massage therapy visits, or those physical therapy visits, and that they would have cut off the treatment long before your own treatment providers did. Or they'll say the opposite. They'll say that you didn't treat enough, that you should have gone back for more visits, that your doctor was recommending additional treatment, and that you failed to mitigate your injuries by not treating enough. But they'll always criticize you for going too much or for too little, but they rarely ever say that your treatment that was recommended by your own healthcare providers was correct. And they do this with the benefit of hindsight, which is always 20/20. The thing about these CR35 exams is that if you're in litigation, you have to go. A good lawyer will try to protect you from having to go, but sometimes there's no preventing it. So a good lawyer will hire an observer to attend that examination. And that observer will do several things. One is they'll audio tape or even videotape the examination. That's important because oftentimes these examiners will claim that they performed tests which they never performed. Or they'll claim that you flunked tests which you didn't flunk. Or they'll claim that you said that you were not injured or you're not in pain when you actually had a test, and you actually told them that you were injured or you were in pain. Over the years we've seen these examiners say really extraordinary things, and the only way to keep them honest, we found, is by audio taping or even better videotaping these examinations. Oftentimes they'll say that these examinations lasted 45 minutes or an hour, and sometimes they'll only spend 15 minutes or 10 minutes or even as little as 5 minutes on you. They're rushed, they're hurried, they've already decided what they're going to say based upon their review of the medical records, they're just going through the motions, and they're not really giving your case the attention that it deserves. So having an observer attend who is medically trained, which we do, and who audio tapes or videotapes it, and who takes notes, can be of great benefit to you to keeping these guys honest. The examiner will eventually write a report of his or her opinions. Those reports are 20, 30, 40 pages long and will include an entire medical chronology, giving the chronology of all the records that they've reviewed. The report will talk about the examiner's opinions and the results of their testing. If you have a good attorney, that attorney will send you the copy of the report so you can have it for yourself. And that attorney will also decide whether to talk about that report with your own medical providers. Sometimes your own doctors will want to refute or rebut that report in a court of law. Sometimes your attorney will actually hire another doctor who can read that report, retest you, re-examine your medical records, and decide whether they want to give a rebuttal report. And that rebuttal report will be based on accurate testing. But in any case, going through a CR35 examination, it's difficult, it is time-consuming, it's stressful, and a good lawyer can try to make it a more pleasant experience for you.